case, the challenge is by one petitioner who is in the 149th Assembly District, one petitioner who is in the 150th Assembly District. And the basic challenge is to a bound volume of designating petitions for a county committee that were submitted without regard to Assembly District and were just alphabetically by town within Chautauqua County. It turns out on later review, only 188 of those respondents are within that bound volume, and therefore on the merits, the case would be dismissed against the remaining. But the merits of this case have never been reached because special term just dismissed on the standing question. But ultimately, the merits here deal with two petitioners, one from the 149th and one from the 150th, dealing with this volume that's bound and doesn't in fact become one petition, because the election law says that they may have been able to be submitted individually without being bound, but under 6.134.2, if they're bound, and they contain more than 10 sheets, which these obviously did, then they have to have a cover sheet. And so we may end up being back up here on that issue once the case gets decided on the merits. But if you look on this standing question, if you look at the history...
Sounds like an interorum argument.
That's right. And quite frankly, the cases throughout the 60s, the 70s, and the 80s, other than the Fourth Department opinion that I'm here appealing today, all the opinions have allowed this standing to object within your assembly district.
Is there any legislative expression in history or otherwise, or judicial expression, that the statutory amendment was a codification of the Mahoney case to which you alluded, as opposed to an overruling of prior law? That has a different perspective to it in terms of the history of the rule that's involved.
The only reported case really is the Maslow case that deals with this specific issue of specifically can someone have standing, and they say it in one sentence that the enactment of said section was not, in our view, intended to change the well-settled law, and in the sentence preceding that, they cite the Mahoney versus Lawley case, and they also cite two other Court of Appeals cases, but those other Court of Appeals cases were basically one-sentence opinions that say we affirm based on Mahoney versus Lawley. So, essentially, the language of Mahoney versus Lawley is what guided the Second Department, I believe, in its decision, as well as the legislative history of that act. And therefore, we respectfully request that you reverse the Fourth Department and allow the case to proceed on the merits.
Thank you very much, Mr. Booth. Mr. Westman?
Thank you, Judge Walker. May it please the Court. My name is James Westman, and I represent 8 of the 246 contested county committee candidates of the Conservative Party of Chautauqua County. With me is Andrew Goodell on behalf of the Chautauqua County Board of Elections. I do think there are some things that we can add to all of these standing arguments, and please recall that our case in Chautauqua County, which was the decision of Judge Mattina having been affirmed by the Fourth Department unanimously, deals with just the standing issue of could these two individuals, could these two Conservative Party members, one living in one assembly district and the other in the other assembly district which comprised Chautauqua County, could they object to all 246 of these people? Now, Judge Mattina ruled that they couldn't, they didn't have standing based on 6-154(2) to object to 244 out of the 246, the other two being individuals who live in the same election district as Ms. Wicks, one of the objectants. We were to have that trial on August the 30th. The objection to those individuals was rejected, or was, I should say, withdrawn by opposing counsel. So, these two objectants, Lucariello and Wicks, are objecting to people, 244 of them, they can't vote for. Now, as to the standing issue, As you saw from the decision, the very brief decision from the appellate division in the Fourth Department, they simply paraphrase the statute. The statute very simply says you cannot challenge somebody that you can't vote for. Now, as has been correctly stated here today, 2-104 of the election law says that you can run in an election district for which you don't happen to reside, in which you can't vote. But that is very, very distinctive. You've got a situation here where if people are aggrieved, okay, on 2-104, okay, maybe they could object in the particular area where they're going to run, the particular election district where they're going to run, if you want to extend 2-104. But that would be as far as you could go with 2-104. You certainly couldn't use that as a justification to say that you can challenge in the entire field, the whole 244.
Suppose you have, let's say, 300 election districts, and they're individual petitions, as I understand it, but then they're put together in one big petition, and the objection is something that pertains to every one of them. Let's say it's a cover sheet.
Yes.
6134 type of objection. Now, if we apply the rule that you espouse, each and every one of the candidates would have to bring a separate petition dealing with that one specific invalidity which applies to them all.
Yes. But
Is that not a very unwieldy procedure? And
no, it's not.
why is
And the reason is, I think, as follows, respectfully. The legislature saw up until 1978 that, particularly in the Second Department, there were a number of divergent cases as to who could challenge and who couldn't. Now, when they recodified the law in 1976, the legislature, they didn't deal with that particular problem. They specifically came back to the election law in 1978, and they did fix the problem, and they provided, Your Honor, that indeed, in order to object, you have to be able to vote for that individual. Now, the particular defect, hypothetically, that you're stating, is one defect, but it affects different people, and each one of those people has to be dealt with as an individual. We try, I think, in our democracy to deal with people as individuals and not lump them together. The legislature certainly codified that in 1978 through 6-154(2).
So there would have to be a separate set of papers, a separate petition, a separate proceeding, and a separate determination in all 300 cases,
There would have to be
even though it's the same issue.
Well, actually, you can cut that in two because an objectant could live in an election district and there would be two candidates in each election district. That is correct. In order to object, you've got to be able to vote for the individual. Now, certainly a motion to consolidate could at that point be involved to provide for judicial economy. However, that is correct. In order to object, you've got to live there.
Next question is, assume, and you argue that this is so, that the legislature specifically intended this result that I've just discussed. What's the purpose? What's the evil to be overcome?
Right.
Or what's the good to be accomplished by obtaining this result?
That takes us to the argument that we heard a few minutes before, trying to, if I might invent a word, genericize this office of county committee person. We heard an argument in the last case that the office of county committee person is a term for a whole bunch of people. Well, it's not. It deals with specific individuals. The evil that you're dealing with here is you don't want to have a situation where one person can create havoc over a lot of different situations that he or she does not specifically have any control over because he or she cannot vote in that specific situation. And let me say that is, I think, exactly why the legislature did that in 1978, so that you couldn't have one person creating these difficulties for all these different candidates. If indeed there's a legitimate objection to these individuals, you got to have people in place to indeed make those objections.
Thank you
and
very
not put
much.
all of these people through all these
Thank you,
things.
Mr. Westman.
Thank you.
Mr. Goodell? May it please the court, I feel a little bit like a pitch hitter at the end of the game. I think it's clear that the legislative history didn't come out with any overriding pronouncement. The only case that's on point is the Maslow case that was after 1978. But I think the previous judicial history is relevant in determining what the legislature meant. As was mentioned earlier, before 1978, there was no specific statutory language dealing with standing. And the courts grappled with the absence of statutory language for about 25 years. The first case, matter of corn, said, if you can't vote, you can't challenge. This court considered, that was in 1944, the matter of corn. In 1950, this court, Mahoney, said, no, if you can run, you can challenge. And then in Boudin, Second Department, 1959, split decision, 4-1, they said, no, you got to vote in order to challenge. And then in 1961, in the Bergner case, this court again said, no, if you can run, you can challenge. And then 1969, 25 years of fighting or grappling with this issue, I should say, with the courts, by a 3-2 decision, the Second Department said, obviously reluctant if you listen to the dissenting judges, if you can run, you can challenge. So there are very two distinct, well-recognized school of thoughts, and the courts were grappling with it back and forth. When the legislature addressed this issue in 1978, they made it clear which of the two schools of thought they wanted to follow. And they said, you have to be a voter enrolled to vote for the party position, not run for the party position. You have to be enrolled to vote for the party position. And I
Is there any truth to the fact that for the last 10 years it's been done the other way?
I have no knowledge one way or the other on that, Your Honor. And quite frankly, I haven't attempted to poll other boards of election or even my own on that issue. A question was raised, I think, with Judge Hancock. What was the evil that was intended to be corrected or the good that was intended to be promulgated? And I think you should focus on that a little bit. Sometimes, as lawyers and jurists, we view things in a technical way, and that's important. But I think we also have to view this in terms of individuals. Even each microscopic name on my cover sheet, I think, is an individual who is trying to participate in the democratic process. And I think we have to ask ourselves, is it right for two petitioners who can't vote for a single respondent to force 244 respondents into court? Is that the essence of our democratic system? Is that the way it should run? I think the legislature answered that question and said no. This previous speaker said, I'm challenging the whole slate all across the Assembly District because I want to wipe the slate clean. I don't think that's the appropriate role for the courts. I think it's up to the voters to decide if they wish to wipe the slate clean. And I think the legislature has reemphasized it's the voter that's the central issue of our democratic process, and not an objector who has a theoretical interest. Another question, of course, that was raised was, what about judicial efficiency? Of course, individual rights should take priority even over judicial efficiency. And I would suggest that if there were a common problem, what they would do is draft a common petition and then just have all the numerous candidates who wish to participate sign a common verification. And then bring it as a consolidated action or
Then
have
we'd reach the
consolidated.
other issue in the other case.
I'm quickly getting off my expertise. The very first case that considered this matter of corn, I think they had an insightful statement. They said it would indeed be odd if the courts were to permit a resident of one district to challenge in the courts a designating petition for public office or party position in a remote district in which the applicant did not reside, with respect to which he had the most theoretic interest, and where he certainly could not express his interest or his preferences in the ballot box. The right to nominate, the court went on to say, it would seem clear, is not more extensive than the right to elect. And if a resident in one district cannot vote for a candidate in another, he should not be heard with respect to any objections he may have to the remaining petitions. In the absence of any statutory language, the court might properly adopt a broader standing rule and look for those who have enough of an interest in the proceeding to make sure that the issues are fully and adequately litigated. But when we have a specific statutory language that deals with the question, I feel that we are compelled to follow it. And there's one other very minor, almost an aside that I might like to mention, and that is we have somewhat of an unusual situation where you can run in a district where you can't even vote for yourself. The election law, however, is clear that there's an independent statutory right for an aggrieved candidate, regardless of whether he can vote for himself, to bring an action. So whenever we're dealing with a contest where the actual candidate is involved, he has an independent statutory right to bring an action. That's 16-102. That is not our case here, of course. So I think from the language of the statute, recognizing the previous judicial history and the trouble the courts had grappling with that, I think we have to assume the legislature meant what they said, and limit standing to those who can vote. Thank you.
Thank you very much. Al?
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence and appear here next Tuesday afternoon at 2 o'clock, at which time this Court now stands adjourned.